We really have to start today by talking about something quite tragic. That recent fatality in Yishun Central.
Yes. Truly
It
heartbreaking.
was just such an extreme outcome, wasn't it?
Yeah.
A 31-year-old woman died, her husband injured, the alleged attacker arrested, and it all apparently stemmed from a long-running neighbor noise dispute.
And that's the key part, isn't it? This wasn't sudden. It had been going on for years. Authorities knew. Mediation had been tried. Courts involved.
It makes you wonder, how did it get to that point?
Well, it forces us to look really hard at the system designed precisely for these situations. You know, these pressure cooker environments and dense housing. We're talking about the Community Disputes Resolution Tribunals, the CDRT.
Right. How could the framework fail so tragically? That's what we need to unpack.
Exactly.
Okay, so welcome everyone to Singapore Property Talk Law. If you want to understand these legal tools, especially with the new changes coming through, please do like this deep dive and subscribe to the channel. You won't want to miss our latest updates. Today, we're diving into that whole framework, the legal side, the community resources, and crucially, how recent policy shifts are trying to give the system, well, more bite.
Let's start with the foundation. That's the Community Disputes Resolution Act, the CDRA. It came into force back in 2015 and set up the CDRT.
Okay.
And its core idea, legally speaking, is this concept of unreasonable interference with the enjoyment or use of a place of residence.
So basically, you have a right to peace in your own home, and your neighbor can't mess with that unreasonably.
That's the gist of it, yes. Unreasonable is the key word.
And the law is quite specific on who counts as a neighbor, isn't it?
It is. It means someone living in the same building or within 100 meters of your place.
But not someone living in the same unit, right? Like if an apartment is subdivided.
Correct. That's a crucial exclusion. That situation falls outside this particular act.
Good to know. And this interference, it's not just noise, is it? People always think noise first.
Noise is definitely common, probably the most common, but no, it's broader. The act covers things like causing excessive smell, smoke, light, or even vibration.
Vibration, like heavy bass music.
Could be. Or construction work, maybe. It also includes trespassing, blocking access to your place, like putting stuff in the common corridor.
Okay.
And even conducting surveillance watching you or your home. Plus littering and issues with pets, barking, smells, fouling, common areas. It's quite comprehensive.
It really covers a lot of the flashpoints you hear about. So if you're dealing with this, you can't just run straight to the tribunal. There are steps you have to take first.
Absolutely. The CDRT is meant to be the very last option. You must try self-help and community resources first.
Like what? Talking to the neighbor yourself, presumably?
Yes, that's the ideal first step. But beyond that, seeking help from agencies like HDB, NEA, the town council, depending on the issue.
And the police.
The police mainly get involved with noise complaints during the official quiet hours. That's usually 10:30 p.m. to 7 a.m. But even then, they often act more like advisors in these neighbor disputes, rather than strict enforcers, because it's often a civil matter.
Right. And then there's the Community Mediation Center, the CMC. That's a big step before court.
It is. It's a mandatory step, in fact. You have to try it.
But I heard, isn't it voluntary for the other party to actually show up?
Historically, yes, that was the major weakness. The CMC process itself is informal, designed to find common ground. But if your neighbor just refuses the invitation or ignores it...
Then the whole thing grinds to a halt.
Precisely. The victim has no choice but to escalate further, which means preparing to file with the CDRT.
And filing. That sounds like a whole process in itself. It's not simple.
Not at all. First, there's an online assessment you have to do, the pre-filing assessment. Then there's the filing fee, $150.
Good.
But the real challenge is the evidence. The burden of proof is entirely on the person making the complaint, and the standard is high.
You mean like needing video recordings and stuff?
Yes, and detailed logs, timestamps, transcripts for audio or video. They even have strict rules for how you need to name the digital files, like year, month, day, time description.
Wow. That's intense.
It is. We hear stories, for instance, about people dealing with low-frequency noise, that thumping sound that's hard to pinpoint.
Yeah.
They've had to buy special CCTV cameras, external microphones, just to capture something the tribunal might accept as evidence. You're basically turning your home into an evidence-gathering station.
It sounds incredibly stressful and, frankly, expensive for the average person just trying to get some peace.
It absolutely can be. It requires immense effort and persistence.
Okay, let's say you manage all that. You get through the filing, you present your evidence, and the tribunal agrees there's been unreasonable interference. What can they actually do? What powers do they have?
They have a decent range of powers for a tribunal focused on community issues. They can order the neighbor to pay monetary damages up to $20,000.
Okay, that's significant.
More commonly, perhaps, they issue specific orders. An injunction, which is an order to stop doing something, stop the noise, stop blocking the corridor.
Right.
Or an order for specific performance, which means the neighbor has to actively do something like remove the items causing an obstruction.
Okay, make them take action.
Yes. And sometimes they can even order the neighbor to make a formal apology.
An apology, does that really help?
Sometimes that formal acknowledgement can be part of the resolution process, believe it or not. Depends on the case.
Let's look at some actual cases. I think that helps make it real. What kind of things have gone to the CDRT?
Sure. There was one case involving karaoke noise. The neighbors reached a consent order, an agreement formalized by the tribunal.
Okay.
It said the person had to keep their doors and windows closed when doing karaoke. And get this, they couldn't do karaoke at all during the neighbor's kids' exam periods if the neighbor gave them notice.
Wow, that's specific. Exam periods.
Yes, it shows how tailored the solutions can be when parties actually agree.
Okay, what about something else, like obstructions?
Yeah. Right. There was a case where someone had cluttered the common corridor shoe rack, plants, a bicycle.
Pretty common sight, unfortunately.
Indeed. The tribunal issued an adjudicated order, meaning the judge decided requiring the neighbor to remove those items. The reason given was that it interfered with the other neighbor's enjoyment, specifically their ability to clean their windows properly and access their flat easily.
So, common areas need to be kept clear for everyone's use and enjoyment. That makes sense.
Exactly.
But what about cases that don't succeed? It can't be automatic that you win.
Absolutely not. Proving the interference is unreasonable is often the hardest part. There was a case, sometimes called the babysitting blues case. The complaint was about noise from upstairs running, stomping, supposedly from a young child being cared for there.
Ah, the classic upstairs neighbor noise.
Yes. But the tribunal dismissed the claim. They found the plaintiff hadn't proven the noise was excessive beyond what, quote, reasonable persons living in Singapore should expect in high-density housing.
So some level of noise is just part of life here.
Essentially, yes, especially noise from children just being children. The court suggested it wasn't proven to be intentional or negligent interference by the neighbor upstairs. It was just living noise.
But for the person downstairs, it's still maddening. That feeling of being trapped by noise you can't escape.
That's precisely the tension. The system requires tolerance, but tolerance has limits.
Yeah.
And when those limits are breached persistently and the old systems struggle to cope, that's where the recent changes come in.
Right, the 2024 Amendment Bill. This feels like a direct response to cases like the Yishun tragedy, recognizing the old ways weren't enough for the really tough, persistent disputes.
It definitely seems that way. The authorities acknowledged the system could be too slow and lacked, well, enforcement muscle for neighbors who simply refused to comply.
So what are the big changes? I heard about new officers.
Yes, that's a major one. The introduction of community relations officers, or CROs. These aren't just mediators, they're public officers, potentially police officers too, with real investigatory powers.
Investigatory, like what?
They can take statements from parties involved. Crucially, they can seek approval to install monitoring equipment themselves. Cameras, noise sensors to gather objective evidence.
Whoa. Okay, that's a game changer. It shifts the burden of proof, doesn't it? Away from the victim having to do all the spying.
It absolutely does. It allows for official evidence gathering. And these CROs have immediate enforcement tools now, too.
Such as?
They can issue a mandatory mediation direction. Remember how CMC mediation was voluntary before? Now, a CRO can order the difficult neighbor to attend mediation.
Okay, forcing the issue. What else?
Even more significantly, they can issue an abatement order. This is a direct order telling the neighbor to stop the offending action or take steps to stop it.
Immediately.
Yes. And here's the teeth. Failing to comply with that abatement order becomes a criminal offense, punishable by fines, potentially even jail time.
Criminal offense for noise.
If you defy a direct abatement order, yes. And the CROs can even get authorization to enter the premises to physically stop the nuisance if the order is ignored.
Wow. Okay, that sounds much stronger. What about the courts? Are they getting new powers too? Speeding things up?
Yes, addressing the delay is key. The tribunal can now grant interim orders much faster. Think of it like a temporary injunction.
So, quick relief.
Exactly. If it looks like the interference is ongoing and likely to cause, quote, substantial adverse effect, the court can issue an interim order quickly to stop the harm while the full case proceeds.
That seems vital for stopping things spiraling. I also read about something quite startling. Mandatory treatment.
Yes, the Mandatory Treatment Order, or MTO, this is quite unique. If the tribunal finds that a psychiatric condition is a significant contributing factor to the person's behavior, the unreasonable interference, they can order that person to undergo psychiatric assessment and treatment for up to 36 months.
Really? So recognizing that sometimes these aren't just neighbor squabbles, but might involve underlying mental health issues.
Precisely. It gives the court a therapeutic option, not just a punitive one, for very specific circumstances where mental health is clearly part of the problem driving the conflict.
That's quite progressive, actually. What about landlords, if it's the tenant causing trouble?
Another gap addressed. The new law introduces compliance orders specifically for landlords.
How does that work?
If a landlord has been notified about their tenant causing unreasonable interference and they fail to take reasonable steps, the court can order the landlord to basically put up a security bond.
Like money?
Yes, potentially up to $10,000 or even $20,000 for repeat issues to guarantee their tenant complies. It also gives the landlord a clear legal basis to terminate the tenancy without being sued by the tenant. It incentivizes landlords to deal with problem tenants.
Puts the pressure on them to act, okay?
Yeah.
And then the ultimate penalty, kicking someone out of their own home. The exclusion order?
That's the most severe measure, yes, and it's still reserved for the most extreme non-compliant cases. It's not taken lightly.
What's the threshold now under the amendments?
It generally maintains a two-strike approach. An exclusion order can be considered if the person fails to comply with a specific type of order called a special direction, or if they defy both an interim order and then the final order on similar terms. It provides clear pathways, but only after multiple failures to comply with court direction.
It really paints a picture, doesn't it? The sheer amount of legal machinery being built up, CROs, mandatory mediation, MTOs, landlord bonds, exclusion orders.
Yeah.
It shows how seriously this neighbor friction is being taken now.
It absolutely does. Singapore is constantly trying to balance that need for neighborly tolerance, which you absolutely need in dense urban living with the fundamental right everyone has to enjoy your home peacefully.
Yeah.
And when you hear the number something like 2,500 noise complaints alone every month, on average you realize this isn't just a few isolated incidents, it's a widespread challenge.
So these new, tougher laws are a response to that scale of the problem.
A necessary response, it seems. An acknowledgement that some disputes become so entrenched and damaging that only stronger state intervention can resolve them. Though, sadly, sometimes not before tragedy strikes.
And even with these new powers, you have to think, it still takes time. Going from complaint to investigation to mediation, maybe an abatement order, court orders, it's not instant.
Oh, due process takes time.
And that initial burden of proof, especially for things like low-frequency noise that's hard to capture, hard to prove, was intentional or negligent, it's still a massive hurdle for residents.
It is. The CROs might help, but complex cases will still be challenging.
So the final question for everyone listening, I guess, is considering how high that bar is and how long things can take, how much unreasonable interference should someone really have to endure before the system steps in decisively? Where is that line in preserving community peace? That's the tough reality we all navigate.